What the public record teaches, how aircraft import problems actually become litigation. Hello yet again. This is Forrest Owens. I'm an aviation lawyer, a private pilot, and an FAA licensed airframe and power plant mechanic. Finally, let's discuss what the public record teaches us about aircraft imports. This third segment is where I want to make this memorable. I want to make this stick because import mistakes are as easiest to understand when we look at how they fail in the public record. The first useful example in is United Technologies Corporation versus United States, decided by the Federal Circuit in 2003. This case involves the denial of duty-free treatment for import aircraft engine parts under the Civil Aircraft Agreement framework. The court affirmed the government. Why does that matter for you? Because it shows that tariff treatment in the aircraft world is not won by industry shorthand. It is won by meeting the legal requirements that support the claim. In practical terms, that means a client should never build a purchase model around probably duty-free without verifying the actual basis for that treatment. The second example is a forfeiture case from the Southern District of Florida. That court describes allegations that aircraft cannons and aircraft parts had been introduced into the United States contrary to law, including theories based on missing licenses or authorizations and even smuggling-related statutes. Whenever one thinks of the facts, the legal lesson is powerful. Aircraft import law is not limited to tariffs and paperwork. Importation can become a seizure problem when the article requires government authorization and the authorization is absent. A third example that's quite a bit more current is in March of 2025, the United States filed a civil forfeiture complaint against a Dassault Falcon 900EX, allegedly purchased through a nominee structure, exported from the United States under false pretenses, and operated for the benefit of Nicolas Maduro and the Venezuelan regime in violation of U.S. sanctions and export control laws. The Justice Department's public filings and announcement explain why that case matters to aircraft practitioners. An aircraft transaction that looks, on its face, like an ordinary cross-border sale can become a sanctions, money laundering, and forfeiture case if the buyer identity, end use, or service support facts are false. And there's a deeper point here. Modern aircraft import analysis is no longer just customs law and FAA law. It is also about sanctions diligence, beneficial ownership diligence, maintenance provider diligence, and payment path diligence. I want you to remember this, and I hope this sticks. Import risk lives at the seams between customs and certification, and between ownership and operation, and between the paper buyer and the real beneficiary. So, what's the practical playbook? First, define the import correctly before the aircraft even moves. Do not let the deal team use the word temporary unless the facts genuinely support temporary treatment. Second, verify the tariff basis. If duty-free treatment is being claimed under civil aircraft framework, document why the claim fits. If it does not fit, price the deal honestly. Third, lock down foreign deregistration and U.S. registration eligibility before closing. The registry problem is easier to solve before funds move than after they're gone. Fourth, run a true conformity and records review. On import aircraft, the records are not merely historical, they are proof. Fifth, treat sanctions and end-user diligence as part of the import file, not as a separate compliance memo that sits in another folder. Large cross-border aircraft deals often fail because the people handling title and certification are not talking to the people handling source of funds and end-use risk. Sixth, document the services narrative. If the aircraft is entering for maintenance, alteration, demonstration, or another limited purpose, the customs position, the operational facts, and the maintenance records should tell the same story. In short, the public record teaches that aircraft imports most often break down in one of three places: the tariff claim, the FAA conformity and registration path, or the truthfulness of the underlying transaction. And when they break down, they can become expensive far faster than most clients expect or otherwise anticipate. Remember this and take this away. The safest aircraft import is the one that can be explained the same way to customs, the FAA, to the bank, and to a federal judge. Thank you for your time. This information is provided for informational purposes only and should not be construed as legal advice. Please discuss the facts of your matter with a qualified aviation, customs, tax, and regulatory counsel before acting. Questions are appreciated, and if you have any, please direct them to admin@aviationlegalcounsel.com. We look forward to assisting you navigate these issues with precision.